Attention, tubies! We've got some intriguing legal drama to dive into today, involving Lee Hsien Loong, the brother of Singapore's Prime Minister Lee Hsien Loong, and two prominent ministers, Shanmugam and Vivian Balakrishnan. Here's the backstory. On July 27, the ministers claimed that Lee Hsien Loong had defamed them by accusing them of acting corruptly and for personal gain in their rental of state-owned black and white properties. Two particular allegations raised eyebrows. First, Lee claimed that the Singapore Land Authority, SLA, gave preferential treatment to the ministers by allowing them to fell trees on the properties illegally without approval. Second, he alleged that the ministers had SLA pay for renovations for the rented properties. The Singapore Ministry of Law even issued a POFMA, Protection from Online Falsehoods and Manipulation Act, correction order to Lee regarding these allegations made in a Facebook post. Now, the ministers are demanding an apology from Lee, asking him to withdraw the allegations, and insisting on damages to be donated to charity. If Lee refuses, they've threatened to proceed with a defamation lawsuit against him. Here's where things get interesting. Lee's response was quite unexpected. He argued that if they want to sue him, they should do it in the UK, where he made the allegations. But is that a viable option? Enter the legal experts. Suresh Damodara, the managing director of Damodara Ong LLC, and Eugene Tan, an associate professor of law at the Singapore Management University, weighed in on this matter. First, they pointed out that the real and maximum impact of Lee's allegedly defamatory statements is felt in Singapore, given that the ministers are part of the Singaporean government and the statements were published for a Singaporean audience, many of whom are voters with vested interests in their ministers' integrity. Secondly, if the ministers do decide to sue Lee in the UK, the English courts might decline to hear the case under the principle of forum non-conveniens, as Singapore would be the more appropriate forum. After all, Lee, the ministers, witnesses, and all relevant parties are based in Singapore, making it impractical to conduct the trial in the UK. The challenges of bringing a defamation suit overseas add another layer of complexity. Both the inconvenience and costs associated with transporting witnesses to London and ensuring video conferencing compliance are significant considerations. In the event that Lee stays put in the UK, two scenarios could unfold. Scenario A: Lee finds representation in Singapore and defends himself, potentially being cross-examined via video conference. Scenario B: Lee chooses not to appear, but the minister's defamation suit could still proceed, with the court determining the merits of their claim based on the evidence provided. So, tubies, what do you think about this legal conundrum? Do you believe the UK is a feasible venue for the defamation suit, or is Singapore the more appropriate choice? Let us know your thoughts in the comments below. If you found this video informative, don't forget to like, share, and subscribe for more captivating content like this. Thank you for joining us, and until next time, stay curious.